Good evening, friends. Welcome to my YouTube channel, Advocate Amit Kumar Gupta. In my series on the income tax cases, the case which we will discuss today is very important case. The name of the case is Principal Commissioner of Income Tax versus ENNOBLE Construction. This case has been reported in 447 ITR at page number 444 and the matter has been decided on 28th July 2022. Friends, the logic of discussing this particular case is that in this case, two important concepts have been given by the Karnataka High Court. The first point is that Section 37 expenses are allowed to the assessee if they are done wholly and exclusively for the business of the assessee and they are not in the nature of capital and personal nature. In section 37, all those expenses are covered which are not covered in other sections. Now the question arises that whether a particular expenditure is wholly and exclusively for the business of the assessee or not, whether this is a question of fact or a question of law, or whether it is a substantial question of law. And the second point is that the powers of the assessing officer under section 131 is that those powers are equivalent to powers of a civil court. If the assessing officer does not have any evidence and the assessee says to the assessing officer that these documents are with some other public authority, then in that case the assessing officer has the power of a civil court to requisition those documents from the other public authority under section 131. In this particular case, the facts of the case are like this. The documents of the assessee were seized by the CBI in a raid which was conducted by the CBI on the assessee. When the assessment proceedings were going on, the assessing officer inquired from the assessee about the evidence on some expenses. The assessee said that my documents have been seized by the CBI in a raid on me. This fact was not disputed in the case. There was no dispute regarding this fact that there was raid on the assessees by the CBI and all the documents have been taken by the CBI. But the assessing officer did not pay heed to this request of the assessee, and the assessing officer said that in the previous year also some additions were made on you for the want of the evidence. So in this case also I am making the same addition. When this matter went to the ITAT gave relief to the assessee by saying that without going into the evidence of the matter, the assessing officer cannot make the addition on the basis of conjecture and surmises. It was the duty of the assessing officer to call from the CBI under section 131 all the documents, and these documents were the copy of these documents to be given to the assessee, and then the assessee have given the evidence of all those expenses. So without exercising the power under section 131, when you know that these documents are not with the assessee cannot go to the CBI and ask for these papers. So the assessing office, it was the duty of the assessing officer also to call this information from the CBI also. So ITAT gave relief to the assessee that this was not done as per the law. So the ITAT deleted the additions. The department went to the High Court. Now the question before the High Court was that whether these expenses were wholly and exclusively for the business, whether it is a substantial question of law, because section 260A of the Income Tax Act and section 100 of the Civil Code of Civil Procedure says that an appeal to the High Court can be made only when there is a substantial question of law involved. So whether an expense is for the business, wholly and exclusively for the business, whether it is a substantial question of law. So on this point, the court said that it is a mixed question of law and fact, and this is not a substantial question of law. There is a difference between substantial question of law and mixed question of law and fact. So the High Court also did not entertain the appeal of the department and gave relief to the assessee. Friends, this case is very important in understanding all those cases in which the documents are not with the assessee because of some unpleasant situation, like there was a raid on the assessee by the CBI or ED or some other excise department or some custom department, and the assessee is not able to produce its documents. Friends, at the end of this video, I am once again repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus ENNOBLE Construction. Thank you, friends.